when due. The job has gone on for 18 months or 24 months. You're at the end. You still are owed money. You have issues. The next parts are covering some of the issues. So if a stop payment notice lawsuit is filed, either because the sub wasn't paid or you've gone through the affidavit, counter affidavit process. So you don't have to wait to the end of the job. In our earlier example, if you filed a stop payment notice and the prime files an affidavit and you file a counter affidavit, that means BART's still holding the money. And so you want the money released, you want relief from it. So the next step would be to file a suit to ask the judge to order BART to give you the money, is the objective of that kind of litigation. But because it's being done because the prime they breached your subcontract, they didn't pay you what you think you're owed, you would name them. And knowing that there is a payment bond out there, a company with deep pockets, is there to pay you in case you're not paid, you want to name them. And one of the things comes up, as I was talking before about having your own advocate, is that a lawyer would advise you, if you were in that situation, to make sure you include everybody who could potentially have liability for your claim. So hypothetically, bless you. So hypothetically, you might have a prime contractor, and they hired someone to do all the exterior of the building, the first tier sub. They in turn wanted to hire you to do all the landscaping part. You in turn hired someone to do all the plumbing, all the PVC underneath and everything. And your PVC third tier sub now shows up on the side, puts in all the PVC in front of the huge garage, covers it with dirt, is going to come back the next week to, put the finishing fittings and put the plants. And in between, the person who was supposed to put in something on the roof forgot, shows up, oh, it's a dirt, with his truck, drives all over the field, gets in, puts up his stuff and leaves. And you show up as a first year sub, and your supplier is, he's out, what happened to all my pipe? It's all broken in pieces. What did you do? I didn't do it. You go around, this has happened, someone's out money. BART's going to say to the prime, hey, you got to give us a complete site. If you broke it upside down, you're phasing, you had your X firm come in and do this, it's not on us. The sub who does the exterior says it wasn't on, so there's a fight, of course, those things go on. So when we're in a situation where you're at the end, the filing affidavit, counter affidavit, you may just want to take action right then and there, and you could. So a lawyer would tell you, don't just name the prime, people typically will name BART, but name also your first year and also name the second one or whoever else. And then usually lawyers will do, you'll see this in complaints all the time. I name George, so-and-so, Bob, so-and-so, ABC company, so-and-so supplier, and Doe's, like John Doe, Doe's 1 through 99. Because you never know who else might have been tied into. The driver might have been tied to any other big company. You don't know this yet. So the litigation has a space to, Doe number 15 is now officially UPS company, as UPS truck drove in there. So you got a big corporation. In litigation, one thing to understand in terms of the way it works in courts, judges and juries don't like someone who's got no relief, who's been hurt, to be left hanging. So they don't mind among the different defendants which of them might have more money. So Mabel, who owns the yard because she inherited from her deceased uncle, doesn't have much money. And the other person who hired, he's going bankrupt. But the UPS driver, that's UPS. So they may, in a litigation context, find some way to have UPS, you should pay someone for what you did and cover this because they're the ones. So that even though you would think everything's driven by the book or the contracts, the sentiments in courts oftentimes drive the outcome that way. So if you're deciding you're going to take this path, you'll probably be advised to name a lot of people, not just one person, just in case something happens. And the other part is the different side of litigation, again, that sometimes happens. Sometimes people are named not because you really think you'll prevail with them, but because for them to defend it, it's going to cost them a lot of money. And they would rather offer you something to settle and get them out of the suit than to pay a pesky lawyer all kinds of money when you really, even if they think they're going to win, just to hire someone, could be thousands, to get advice, have a minute to answer an answer. They go to you, they look, okay, Bob, what would it take to get me out of it? You sued me for $50,000, it can't be that much. Go, I would take $5,000. Okay, $5,000, you sign a release, she's out of the lawsuit, the 4 remaining ones stay in there. So sometimes people are named not because they truly did something wrong, but because the person filing is hoping that they'll offer them a settlement and give them a little bit of money and get out of it. It's a strategy people do. People would say, why are you on? They ask us upstairs, well, if we do this, will we get sued? And general counsel said to me, he said, well, of course, anybody can sue anybody. If you're willing to pay a lawyer, they'll sue. Whether you can win is another story. But we can't ever guarantee, people ask us, it's a project people in different departments, will this keep us from getting sued? And I say, well, no, we can never guarantee they won't sue you. You may have a really strong defense, But as long as someone's willing to pay someone, they can walk to court and file the complaint and see what happens. Even there, let me go a little deeper. It's not in the slides, but in terms of what I've seen happen with our own cases when they come in. There's stages that you have to proceed in litigation. Okay, one is the actual, well, let's say with a demand for money. Initially, it's a demand. You owe me X amount of money. If you don't pay me within 30 days, I'm going to take whatever action I can to protect my rights. It's a demand letter. So I didn't pay you. Time's passed. So now you go into court. I demanded this. I owe this. You file your case in court. Filing doesn't really get everything going until you serve the other party. So many times, strategically, before you have to trigger all the money rolling, you have the filing, which may be a filing fee, and you send the defendant a copy. I've just filed this. Once we settle it, I'm going to get into, you're practically in court. Unless they serve you a service of process, you're not really yet triggered to file an answer in court. But you can not have to hire someone to file the answer if you settle it with the initial correspondence. So they're saying, I got it in court, and I can make it real by serving you unless you do something beforehand, so strategically. So the person says, oh my God, I've been sued. I would say, wait, have they served you? No, okay, we're not really in court yet. But once they serve you, we're obligated within 30 days to file an answer in court. And to do that, you'd have to hire a lawyer to sign the answer to get it in, to get it right. But short of that, strategically, many times firms will send a copy of the claim that's been filed, but not yet served, see if that triggers a response. 30 days go by, you haven't. The court will say, unless you serve it within X amount of time, your lawsuit's going to be dismissed. So getting to the deadline, fish or cut bait, are you going to do it? So once they figure they have to, now they get a process server, knock on the door, are you George Smith? You've been served. Now you're legally obligated as George Smith to file an answer in court within 30 days, or you default in a lawsuit. You don't want to lose, so the process gets rolling and it gets expensive. But again, the idea is that you don't want to lose your chance to do something within the deadline. If it's filed, you got it within time, at least you locked in. If you don't file within 90 days, you can't even go into court to enforce this. So that's the reason for picking on that date a lot with the slides. Okay, so go to the next one. So, I described a little bit of going into a stop notice suit, that a lot of the prerequisites, like we said before, are short of going into litigation. So relatively, in terms of cost effectiveness, you haven't yet triggered, until you file the stop notice suit, the larger expenditures. There's letters, there's submittals, there's notices, you sign something under penalty of perjury. But this is the other remedy. If you don't get through the stop notice process or stop notice bond, any of those, and you have to file a breach of subcontract lawsuit, then you're saying your subcontract was violated because they didn't pay you what both parties agreed by terms of contract. Contract enforcement is its own civil litigation. So, it has some drawbacks just inherently. One is, of course, you no longer have, in this case, we're not holding money or anything. You're just suing someone for the money back. To do that, it's expensive, just to be upfront with the matter, why we put it towards the end here. It requires, of course, engaging an attorney. There could be significant potential court costs. It's not free to go into court. They charge you to have a case filed. They charge you when you have a court reporter. They charge you at mediations. All that is on you because you filed the lawsuit. All this money's going out and you have no money in hand yet. So you have no guarantee of outcome from the judge or jury. You may be telling the truth. Your expert might be telling the truth. But knowing human nature, your expert might have an accent. They might not be too tall. They may wear glasses and get a little nervous if people yell at them. They're a good accountant. They know it cold, but when they speak and someone yells at them, and from a jury's watching it, they're looking at this person who sounds a little bit like they have an issue. And then you get the other side, and they have someone who's tall, got nice-looking eyes, perfect type, deep voice, and he smiles at the jury and says, oh no, this is consistent with industry practice. And the jury goes out and goes, I like that second guy. Your person is telling the truth solid. There's no guarantee when you're in this context that the truth will prevail. It's how does the evidence play? And I can say here, and I do any given point of the day, I'm looking at contracts and very specific, interpret what those terms mean for our contractual fights. But when you leave our environment here and you're in this area, you're out of your own and you're in their world. And if a judge doesn't let you present your evidence, you can't present your best case. Now they're left with something less. And if the other side comes in with a star witness who everybody recognizes, oh, it's so-and-so, guess what I saw in court today? They're going to forget what you said. They're remembering your star speaker who came in. All these, it sounds like visual, artificial type things, but human nature being what it is, it's what can sway things in court. So you got to go in with eyes wide open knowing that these are the variables. So attorney, like I was mentioning before, just to hire someone with us, when we hire people for BART work, it's several $100s per hour, depending on the nature and specialty of the work. We had, just as an example, maybe a few years ago, we had a problem with our radio signals underground in downtown San Francisco. There were some disputes going on. People were trying to disrupt the trains. And we have equipment to let people receive their cell phone signals in the tunnel. We pay for it, BART does this. And so when this was going on, someone within the authority decided to lower the strength of the signal so it was hard to call up above the surface. Huge protests about it from the people who were protesting, saying, oh, you're censoring us. It's violation of First Amendment. It wasn't. But to get to defend us, we needed to get a First Amendment specialist. So we went to outside counsel, as we do, and that particular person was $950 an hour. And we were prepared to pay it. Everybody approved it. We got the policy we were looking in place. We survived the FCC, survived courts. We got out of everybody thought, you're going to have sink. This is a terrible thing. It was in Mateer and Ross, it was in the papers, but our policy stood. It's a lot of money, but at that point, it's what needed to happen for the needs. You have a smaller case, more modest, maybe you don't pay as much per hour, but these days it's not a cheap thing to do. When we talked to outside counsel about having to go into litigation, and we talked about how much it will cost, they've said, well, it could easily be $250,000 by the time you're done with the trial. And you just got to picture this. Again, BART contracts aren't like your regular small contract pouring somebody's driveway or fence. We have very complicated systems. We have public works standards. The BART facility standards are pretty high end. They meet the ISO standards for technical systems issues. You have to have quality control. You have to have people watching it. It has to survive a lot of environmental pressures, not like regular construction. And they're very demanding. In building the SFO extension, the prime had us building a vent structure. It's like a 4-story building from underground the tunnel to the surface. The subcontractor did a bad job. They came from LA. They really weren't doing the right thing. We looked at the concrete poured below ground and had voids. And if you're going to, this is our fans, they were huge fans. They spin to air out the tunnel. It needs a very solid foundation to survive just the vibrations. And then we're into the San Andreas Fault. We had seismic standards. The sub who did the work was not doing it right. They're actually fraudulent for other reasons. But we inspected, said, we can't accept this. And we went to the prime, Tudor Saliba, said, look what's happened here. This is not acceptable. He saw it, he goes, you're right. The whole thing was completely chipped out. He fired the sub, and then they poured us a whole new vent structure near Ceremony in South City. But our inspectors caught it. It was wrong. That sub, they had hundreds of thousands spent on that one. It's like building a 4-story building for special purposes, and they did it bad. You couldn't fix it. You had to just tear it all out and start again. But all of that was on Tudor Saliba's ticket because their sub did it. It wasn't us. We had correct specs. Our inspectors caught the problem, and he absorbed it. Somewhere else he probably made the money, but at least on that instance. Yeah, but as it turned out, the back part of that story, the sub had other issues with Tudor in LA. They'd already been caught for other issues, so they were going out of business. So really, the prime had to absorb it. Another risk as a prime, if a sub goes under, as far as BART's concerned, well, you have to answer for them because you hired them. So our books also, another side point on our books, I said they were biased. One of the things in them, if a prime contractor has to substitute a subcontractor because of performance, our book doesn't give that prime any extension of time to complete the job. So the concept is this, the prime picked their team, all the subs, and they live and die with them. So they might have had a sub who's charging a premium, but they're always on time, they're there to do it all. And somebody else says, I can do it for half the price. Oh, that sounds great, but what is he cutting out? BART's not like gonna be forgiving about its standards. Someone went on the cheap, someone comes in, doesn't show up, doesn't pour it. As far as we're concerned, prime, go fix that, and we're not paying another penny. It's really that demanding. So the general conditions are clear that any issues with the sub belong to the prime. Any claims from the sub have to be vetted to the prime to make sure they endorse that it's a valid claim, so then we can follow up with our remedies. So there is a lot of burden there put on the prime contractors, and really the first line of communication with subs is with their prime. So it's awkward because, of course, we're, as Harry said, we're here trying to provide support for subcontractors knowing you're in this dynamic situation, but contractually that's still something we're somewhat limited by. So again, litigation is a difficult avenue, not always available. And frankly, if part of the suit is on a small amount of interest on a late payment, do you want to go this whole path for a few thousand on top of an old payment? People are realistic, and even though we put this up as a remedy, I understand realistically it's not really the easiest thing for people to step into. So then the next slide, get indemnity. So this is other issues that come in under our contracts that are flow down to the subs. So indemnity, we require the prime to cover us for any claims that arise during the performance of the work within the corners of the contract. That means they have to hire an attorney. If somebody's wall was damaged as you were backing up a truck, that property owner is going to file a claim. We're going to tell the prime, hey, you got to defend that. And you're supposed to have insurance on it. And so we ask insurance in our contracts. And oftentimes the primes will flow it to a sub. Hey, give me insurance to back up mine. The indemnity cannot be used for sole negligence or willful misconduct or for defects in designs. So that last one, it's important. And this occasionally happens, of course, if BART goes out with a contract and hypothetically the design for the retaining wall is wrong. You have, in my hypothetical example, a drawing that shows a straight level wall. When you go to the site, it slopes down for 20 feet at the back end. You're going to need different support for a wall and the drawings don't match. Something's wrong. So if we had defects in our designs and what we gave you and you're out money, then in that instance, you can't say, oh no, but you have to identify this extra claim for extra digging or extra cost. No. If we do something wrong, then you'd be able to say, no, in that instance, you really should stand for that. But if, like I said, if what arises because someone executed the work badly, that switches it around. BART contracts include broad indemnification provisions requiring the prime to defend any claims filed associated with the contractor's performance of the contract. The prime contractors often flow this down to the subs, and that's just the nature also of the business. I got to go to another one of the examples we had. We had two, same firm, subcontractor, relatively smaller African-American firm doing plumbing type work. In one job that was relatively modest, the prime contractor brought them in to do work and did not require that they provide a subcontractor bond. It was a modest amount of plumbing work. And so it was a BART job. The sub was able to come in. They didn't provide a bond. They stayed on the job. We had another job within a year that was $100 million, huge job. The prime contractor's bonding company said, look, you need to get bonds from your subs. I can't carry the whole $100 million. So if you had a sub doing 10 or 12 million worth of work, the prime's bonding and insurance company said, get that much from them. So that prime in their subcontracts put terms, you need to provide a bond. So we get into the project and the prime says, I need to drop ABC company. And under the state law, when a firm who's listed is going to be dropped, they have a right to a hearing under the listing law before they're dropped. So we're having this hearing, and the sub is arguing, wait, last time I worked for George, he didn't ask for a bond. Now he's being mean to me, insistent I need to stay on the job and I shouldn't have to provide a bond. The hearing officer said, wait a minute, your subcontractor, paragraph 14 says you're required to have a bond. Did you read this? Well, yeah, but I didn't think he meant it. And they go, well, okay, well, last time he didn't need it. And so then we asked for the prime. He testified, and the prime said, look, I like you, Bob, you're great, but my people tell me I need this. I can't have you on the job without a bond. I'm not allowed. I couldn't win this job unless I did this. I wouldn't be bonded. Your bonding company would have backed out. So a very convincing case. The judge heard it. They felt sympathetic to the sub, but they were out. They did not have the resources to get the bond. Some firms are more bondable than others, as you know, that's a whole other topic. But in that instance, they struggled. So they could be on a BART job where the prime didn't flow those down to them. But once they did, they couldn't really be in there. They were dropped, got a new firm. So it is important to understand that even though, as I said before, our provisions with the prime are very unforgiving and large, they're very demanding, the primes also are free to flow those down to the subs based on the terms of their subcontract. And you got to be aware of that because the contracts we have, let me again go off the screen for a little bit, in that our contracts are somewhat carefully structured to describe all the conditions, but it's not apparent at first blush. Let me explain what I mean. When I first came to BART, I've been in BART over 30 years. So when I first came to BART, the contracts we issued, the engineers would put together a complete scope. They would do the estimating, put quantities, distances, everything in the specs. Our books would mix the bidding instructions with the technical requirements, with the bonding instructions, with insurance, and it would go up and down throughout the book. So we reorganize them. The way they're set up now, all the bidding instructions are in the instructions to bidders. All the invitation, what the job is in the invitation. The general conditions are standard boilerplate legalese that covers the administration of the job. Then there's the supplementary conditions that modify the general conditions. They then adapt the job to that particular supplementary conditions, and you have the basic contract forms. We have the BART contract specifications. But they're organized differently than they used to. It used to be everything you needed to know about it is in that one chapter. The way we work now, we follow the Construction Specifications Institute methodology, the CSI scheme. So It follows a similar approach to what Caltrans does. They have different divisions of specifications governing different qualities of the job. So division 1 is all the administrative things, how you keep photographs, how you keep submittals, schedules, payments. Division 2 is demolition. Division 3 is site preparation. Division 4 is structure. As the numbers go up, you're doing more sophisticated work. By the time you get to division 30 something, it's train control modernization software. It's a very complicated technical thing. That's the way BART is organized. That's the overall picture. So in a given contract, what we do is that we'll invoke a certain chapter of the BART facility standards that's applicable to this job. So it'll be a cross-reference, but what you'll physically see is a single page that says BART requirements regarding welding. There's a whole BART standard. It could be 30 pages long of welding standards that by cross-reference is suddenly part of your contract. Unless you go out and look up the BART facilities at BFS and see it, you may not have a whole picture of what this involves. So in this case, when you get things flowed down, even though we put so much in the prime, subcontractors actually assume a good part of that because they basically are given whole chunks of the job with all the conditions that apply. So you go to the next slide. Contractual indemnity in BART's contracts includes duty to defend. This is the hiring of the lawyer. Defense obligation arises from a covered claim even if fault is not proven. So that means that, okay, so you have a job, someone files a claim, again in my example, maybe part of someone's fence started sinking after you started dewatering. Our job asks you to dewater. Our book said to do it. You're dewatering it, but someone files a claim. So even though you were following our book, it wasn't your fault things started sinking. We should have realized proximate property had some impacts. But if the claim is filed, one would still have the defense obligation even though you're not at fault. The way our indemnity reads, defend us. And if at the end of it, the trial, the jury says, the reason was because the specs called for this, then you say, okay, BART, you owe me what was there. Then we paid the liability that was on us. But getting to that stage, all the costs of the lawyer, the witnesses, it's all on the contractor, it's all in indemnification. So that's what, it's a simple sentence, but that's what it means. It's a significant burden. And when we're negotiating contracts, that topic comes up with corporations all the time. And we really have to, and then we say yes, and we go back and forth, but it's a topic that carries some obligations. And if you don't have it, you save yourself something, but we like to keep it there. So the parties can agree on the timing and immediacy of the notice regarding pending claims and lawsuits, and possibly the right to select defense counsel. So what that means is depending on what the lawsuit is about, BART might want to be in the courtroom to try to push it because either there's a policy or some significant issue at play, and you don't want to leave it to the prime contractor to kind of pay the minimum to get out of the lawsuit. For example, the issue that we had come up once was with the federal conditions. We have federal grants. They require that we have certain disadvantaged business participation, non-discrimination provisions, provisions against Buy America, other issues. If someone sues on one of the federal interests, one of the conditions that is a requirement of a federal grant, we don't want a judge telling us, oh, you can't do this, and now we lose our eligibility for the grant. We may lose millions. We want to make sure that we're all within the criteria to continue to be eligible for federal money. And the lawsuit might put us at odds. So we may want to be part of it to make sure they argue the right thing. And so this part of being part of the defense code can't come up depending on the issues. We had in SFO a federal requirement to track the truckers. The trucking is different because a trucker could either own its truck and have somebody else drive it, or own it and own the trailer and somebody else drive it, or they drive it, own the truck and the trailer, and you get a different amount of money. From the disadvantaged business enterprise, the DBE requirements of federal grants, we're supposed to measure how much money has gone to the DBEs to see if the prime meets its goal. So it's important to know what's the dollars going to them. So if you say, I'm a trucker, we were asking, what kind of trucker? Do you own the truck, or are you just a driver? Do you own the trailer? And different dollars are going, and we add it up for the program. Well, in our fight, this is one that goes with this issue, the prime contractor was arguing he didn't need to give us the trucking reports. We were saying, yes, you do. The federal grant requires it. Yeah, but my contract has this clause that gets me out of it. We said, that's not the way to read it. Well, that's the way I'm reading it. Well, you're not supposed to. Well, I want to. It was like this. We went before the Disputes Review Board, and this Disputes Review Board agreed with the contractor. They said, that clause means he got out of it. I said, well, it doesn't help us. We still need to get that information to be eligible for the $750 million federal grant. We can't let it go. We need the reports. We're telling the prime, give us the reports. Well, I don't want to. So what we did, we withheld from the invoices the amount of the invoice for truckers until we got the reports. And time went on. We kept fighting every week, 9 months later, almost a year, finally gives us the reports. The amount, of course, that job, it was $1 million a day. It's a $500 million contract. So He had, the trucking added up to almost $1 million, and he put in a claim for late interest on late payment. He said back then under the contract, the DRB said you were supposed to not withhold this money. I was correct. We withheld it to get the reports. He gave us the reports. We paid him interest on the money, but we got the reports, and we still got the $750 million federal grant because we needed to fit the federal requirements. Later, we changed our books to say you cannot take to the DRB any DBE federal issues. Those are outside of what can go into that form. Other places to take. We don't want to be at odds with the legal requirements we have with our grants. So we remove those as issues to be brought before the DRB. It's held, so we don't want the federal conditions to be subject to someone's own sense of what it should be. They're already set in stone. They're set in Washington. We sign things, we follow it to the letter. Our department really tries to make sure we fit all those things. We get audited. So it's really, they're very demanding on that respect. And we couldn't have any leeway. So we stuck to our guns. And we might really want to be in on a fight if someone's fighting about it, if it's going to court. Otherwise, under indemnification, the promisor, the contractor's option to select counsel and control defense or pay a portion of the fees, it's all up to them. You just settle the case, tell us how it ends. Usually it's up to whoever's defending it. Okay, so the next slide. So written change order. This is going back to a topic we had before. Again, the whole theme tonight is both obligations and benefits under the subcontracts. In this instance, it's kind of an overlap because you have an obligation to do work that's within your scope, but when it's changed, you may do the work, but you want to make sure you get paid for it. And this is a delicate area, as I said before, in BART sense, actually leading up to the current support services. One of the sensitivities in our office was trying to be aware of the fact that, we are here to basically make sure looking out for BART's rights. And so our contract might call for a very demanding kind of request of the prime. But between the sub and their prime, or a second tier sub in their first year, there could be any number of reasons why they have legitimate fights and dollar issues that don't directly involve us. But it's awkward because when that happens, these slides are focusing on what should a sub do when changes come in. So I'm switching hats a little in this since I'm not really wearing my BART hat. I'm thinking, okay, as a sub, we change the work, and then we ask them, okay, what Mr. Prime or Ms. Prime, what would you charge us for this change? They give us a price, if we're okay with it, we issue a change order, and then it's good to go. That change might affect the work of a sub. So the prime really should get the sub to agree on what they're agreeing to before they hand them more work. So how to deal with written change order? A contract usually requires the prime contractor to proceed with change work directed by BART in writing. So in our contract, we have what's called a change notice to proceed. The contract says if we have to have work done immediately a different way, we'll give you that kind of change notice, which means start doing it this way, implement the change, and we will pay you what it calls like time and materials till we agree on a lump sum. It's called like a force account approach to that. But if it's directed, then the word directed is loaded here. That means we're telling you do it this way. You go, okay, I'll charge you, but I'll do it the way you do. That's an extra charge. It's a change order. You should be owed money for that. Subcontractors should obtain a written change order from the prime for changes to their subcontract. And you should get that. But again, I realize that depending on the negotiating leverage between the sub and the prime, depending how they are and how one is, trying to do business, you may not want to push it too hard, or in your own sense not want to, but it's a risk to not ask that your contract be changed when they're adding more work or modifying what you did. We had an unfortunate incident with a designing firm, and I keep giving examples of SFO because so many things happen there. The sub envisioned doing all the design for, in this case, do the conduits holding the cables. 8 miles of tunnel, you can estimate what it would be. They figured a design initial one for the whole 8 miles. They get it approved, they do another, and then the final as-built. 3 submittals, has a team to do it. After they win the job, the prime tells them, oh, I don't want to do it that way. I divided the job into 6 segments. So give me the submittals on the segment number 1, then another one segment 2, and like this. So 3 submittals here, so 6 times 3 instead of 3 submittals. Her staff had to do those drawings. She had to pay them. But the check she had, the original subcontract, assumed only this much labor. It had more than tripled, and Tudor was not giving her a change order. And it was a jam. It was really serious issues financially. I get a call one day from our Office of Civil Rights. They really were trying to help, and they called me, look, can we pay her, can we write her a check for $250,000? I said, wait, we don't have a contract with her. No, but she really needs the money. Yeah, I understand that, but we can't, even with these procedures we talked about before, we do not write a check to the sub. We may pay the prime to pay the sub. Our contract is only with the prime, so it's just not something we do. And he was unhappy. He said, but look, she's suffering here because look what happened to her. Oh, that's terrible. But it doesn't give BART a legal right to write a check to someone. She had a claim, went through the process, eventually got something, but really was burned because the prime changed their work on her and did not accommodate any extra compensation. He said, I didn't change the 8 miles, still 8 miles, but her assumptions were one, and his approach changed it. And in a couple of the fights, we asked the prime, how come he didn't tell someone of what he intended to do at the beginning? Because it was after award he sprung these changes. And his answer was, I didn't want my competitors to see my approach. They would have taken advantage of it. That's how I ended up being low bidder. So no, I waited till afterward. Now I tell you what I really want to do. In one instance, he changed the way he was going to do the rebar. So remember in my example, it's 8 miles a tunnel. There's a lot of rebar to build a tunnel. He had a firm from LA listed to do the rebar. And he changed the size of the rebar. So it was less weight. And he said, less weight, give me a discount. She said, no, my expenses are in labor. Now you have a bunch of skinny rebars. That's how many more rebars I have to tie. My labor cost, my price goes up. He goes, what do you mean? I want you to lower your price. I said, no, I bid based on the thick rebar. You don't want it small. My price goes up. The tonnage doesn't matter. It's how much labor to tie it in. And if you've seen rebar, you see these guys been tying each wire to, that was the work. And she was saying that she was correct. He wanted to fire her. She had a substitution hearing. We knew it was Tudor Sully. He's very, persuasive in his ways. So we hired an ex-Supreme Court judge to be the hearing officer for the hearing. He was retired. He was in the business. So, hey, we figured we didn't want, if it was going to be appealed, we wanted a good decision. And the judge had this, and Tudor Sully has his own legal background. And he asked the question I just pointed out. He goes, well, wait a minute. Why didn't you tell her? So you agreed that you had her bid with the thick rebar, and you're changing it. He goes, well, yeah. He goes, well, why didn't you tell her before? He goes, well, then my competitors would have seen my advantage. I don't want them to know. So then you admit you're changing her subcontract, so you can't let her go. And he's like, oh. So they went on the hallway, and about 20 minutes later, they settled. She got $1 million, went to LA, didn't do a thing of work. He hired Bay Area Rebar for his price. He still made money. But the settlement, because she had a right to stay on the job, and he wanted her out because he had somebody else willing to pick his price. So what would it take to get you to leave? Well, $1 million would make me happy. So she did. But see, the primes will do that afterwards. In his case, he got burned with that. I mean, not completely, he made money, I'm sure, at the end of it. But you have other situations where the sub assumed one thing, and that, like my example with the firm who did the design, and the prime had other ideas, but didn't contractually get a change order to her contract to make sure she got payment. So it took a bit of fights, months of very painful exchanges, several reports on the ombudsperson. I talked about it. The ombudsman came and advocated and pointed out why he thought she was owed something. But we were so, hey, we don't have a contract with her. You got to get Tudor to agree to pay her, and he didn't want it. It was just tough.
He made money elsewhere. He just put another subcontractor.
Yeah, no, that'll happen.
Was she a small business?
She was a small women-owned business headquartered in Oakland. So it was tough. So constructive change orders, these are ones where they don't issue a change order, but they modify the job. That's the concept behind it. So they're changes in the work that are not reflected in a written change order, but occur when something happens to change the requirements of the contract. So you came in expecting the site to be level and even and uncluttered, and it's filled and all lumpy. It's not what the drawing showed. So it could be unforeseen site conditions. Maybe we have unsuitable soil and you can't really be able to build on it. You could have directions to perform new work that wasn't in your original scope. You could have defective specs. They don't show what you're seeing, or they point you the wrong way. You have to redo it. You could have delays by the owner who didn't provide. Sometimes we have district furnished materials that you're being hired to install. You're waiting and we don't give it to you. That's material we didn't give you. It might be on us. Access, we didn't let you in to do the work. Now you're behind. Differing other information that changes what you assumed or was in the original signed contract. And then over inspection. You've done it right. You go, oh no, do it again, and you didn't have to. That could be, this doesn't happen too often, that one. So on the next slide, how to deal with constructive change orders. The key thing that I would suggest is a notice. So you want to have a notice to tell someone, hey, you're giving me this extra work. Make it a matter of record. You want evidence, you want a record, email a record, maybe an attachment, something. Submit a written proposal for the cost of performing the changed work. Will help document it. A written confirmation of the cost for the extra work. So Bob, last Friday we spoke about pouring the new foundations. I've done my estimate. The value is going to be $85,000. Here's my numbers. I'll expect to be paid for it. If you have any problems with it, send me back. It's a record that you had that money and you were doing it on the assumption you'd be paid. If you get into fights later, that record will be helpful. So you want that in the record. Let's see, the last one is, so you could ask for a request for equitable adjustment. We call it REA here. People have different terminologies. You know, request a change order, contractor demand for payment, any number, you could call it a claim. You're asking for money. In this case, you couch it in the context, you're proposing something that they're changing on a job to reflect that it's beyond what you originally had. This is above and beyond, and here's my price if you want me to do this. If you agree to this, then I'll do it. If you don't, maybe I won't do the change. You know, you got to pick how to express it. Okay, so on the next slide, there could be claims against subcontractors. This is the problem when people float things down. If the subcontractor causes someone to not finish something between that has liquidated damages, the prime might hold the sub responsible. So what it is, liquidated damages are a fixed amount that's assessed for late performance. At BART, it's usually several $1,000s per day for each day that it's delayed in completing the job. It can be passed from the contractor to the subcontractor if the subcontractor allows for the pass down and to the extent the subcontractor is responsible for the delay. So excusable delay can extend the time for completion. So remember the other side, it showed things BART can do wrong. If that's the reason you didn't get finished on time. So you're supposed to have 6 weeks to do the work starting May 1st, and Daniel's in charge of the site. He goes, wait, we got other work we haven't finished. You can't start till May 15th. You've lost 2 weeks. The deadline at the end that normally charges $5,000 a day isn't fair. When you're supposed to have full 6 weeks, you only had 3 to do 6 weeks worth of work. In that scenario, you should be arguing it's excusable because BART delayed me getting access, so you should be able to get out of it. Now there's a separate topic that comes up on some of our jobs, more and more so now when we do work, because we're redoing all the original system, measure our hours like $3-4 billion. RM3 has money for similar work for new cars and other things. When one is near the BART operating envelope, we have rules that do not delay revenue service. So we carry 300,000-400,000 people a day. They can't be slowed down. So some of our jobs require the work done between midnight and 4 in the morning when trains aren't running. But we have a really strict provision in that one. At 4 or 5 in the morning, if you're not out of there, this last bullet can kick in. And it's significant. It could be thousands of dollars per hour to hold up the system. You don't want to hold up the system. So our normal rules are before you're going to do work in our operating envelope, you have to give BART a site-specific work plan. Say, here's my plan on how I'm going to go in at 1 in the morning. I'll set up at 1:30. I'll be pouring, doing whatever, 1:45 to 3. At 3:15, you'll start demobilizing. By 4:15, I'll have out. And your whole plan's laid out. If it looks feasible, okay, go ahead. That has to come into BART 6 weeks before the date you want to go into that area. And we have everybody at BART who's interested, a stakeholder, look at it. If it's near a station operations sees it. If it's near the wayside traction power looks at that plan. If it's train control, look at, every stakeholder sees the site-specific work by SSWP to gauge whether it's adequately protecting BART and it looks realistic. What kind of equipment, like for example, you can't bring diesel into our tunnels. So if your plan says I'm going to bring a diesel generator for lighting, oh no, redo it, it's not approved. But once it's approved, then usually the week before the day you wanted to get access, we'll give you the final say, okay, all your plans are approved, you're good to go, get ready, next Friday you're in. Let's say that we're anticipating that, just to pick one, we may build the Irvington station that's in between Fremont and Warm Springs. There's space for it. And if it opens on time, we'll get so much revenue per day. So we put liquidated damages for that because we anticipate opening by May 1st, and we think maybe City of Fremont's going to have something that needs access there by that day too. So we put, just to pick a figure, $6,400 a day because we think that's what will be damaged. For stations, that's not that off. It's usually 70 million, so it's the figure. And what will happen, this is the hard part, is you get to May 1st in my example. Nobody's ready. The City of Fremont isn't ready. The other one's ready. Sure, you're going to be delayed 30 months, but all that we thought would happen on May 1st isn't happening. It doesn't matter. We had several cases in the state where the contractor goes into the judge and says, look, they put $5,000 a day because they needed it open for the big new building opening next door. Well, that building didn't open for another 6 months, so why should I pay? And they have no argument because they say, well, back when you bid, was it reasonable to anticipate that they would have it? Well, back then, yeah, but now it doesn't matter what actually occurred. You're liable for the damages. And the way to illustrate, the other example we give to kind of gel, reverse it around a little bit. Imagine that we had an incentive. So our deadline to complete the work is July 1st. But if you finish early, I'll pay you $1 million to finish May 1st. C.C. Myers had it to replace the bridge and the Santa Monica Freeway. If they finish early, they get $1 million. So you have that, an incentive to finish early. So you're the contractor, you won the job, July 1st will be it, but to finish May 1st, you do extra premium time. You're going gangbusters. May 1st, you're looking at that extra $1 million. It's almost, you can count on it. April 15th, he goes, you know what? We don't really need it after all. So go ahead and just finish in July. Just let's forget about the incentive. That won't wash. If you bid on that job, you're going to get your incentive. He goes, you may not need it, but I'm going to be done May 1st. You owe me the $1 million. To try to cut it off early, right when you realize you're getting near it, doesn't hold legally. And it's kind of the flip with LDs. By the time they kick in, it's too late to argue that they're too high or that you shouldn't be subject to them. Did you meet the deadline or not? You missed it? Then they kick in. The value is not on the table. And people try to argue with judges, contractors, that they should be out of it because they really weren't truly damaged and it doesn't control it. You're liable. So it is unforgiving that way, but the alternative in the codes was that they don't, if you think of the alternatives, that means you have to prove every dollar we had lost for every day they were late. That means my time, how many hours, how many passengers, how do you quantify and prove it? It's very difficult. And it's a paper, because you get a huge amount of paper depending on what you're talking about. So instead of all that, just pick a figure and let's go with it. So the state likes that. It's very straightforward. It's predictable. Before they bid, they knew it was there. So live with it. And again, it's pretty straightforward. BART likes them because then we're able to get a fixed amount. Now, one thing, the other side of the coin that happens, just because this is the way our conversation is going upstairs, is that if the contractor is late on doing something and they get LDs, but if BART delayed the contractor from finishing on time, and you all have to keep renting a trailer an extra 2 weeks because of us, the contract would have the reverse. Then we might owe extended overhead. The prime can charge us for every extra day beyond the completion date. They plan on finishing May 1st and be gone, and now because we delayed them, they're there an extra 2-3 weeks. That could come back to BART. So instead of collecting money, it swings the other way. We're paying out daily rates of $4,000 to $6,000, depending on the prime's cost. It could be several thousand easily, $3,000 or $4,000 is not unusual, to pay the contractor every day we held them up. So there's obligations and benefits on both sides that go with that kind of situation. Just be aware of it. So let's see, we don't have the slides up on the screen, but I think I have one more, and I think this will wrap up the piece here. Two more. Okay, so there could be claims of back charges against the subcontractor for things they did wrong. The prime might be out, so be aware, especially if the subcontractor provides that it can back charge you for things that they expended on your behalf. BART has provisions like that for the prime contractor. So if the prime contractor had to do something we need it done and they aren't doing it, we can't tell the prime, we're going to do this instead and give you a unilateral credit change order to make up for this piece that we had to put in because you weren't able to muster it. And the last one we did was actually very conscious. The prime said, look, I can't do that. You know, my person left or another job. It's the very end of the job. We essentially invoked that section, took out a certain amount of money for us to do that piece and close out the job. We just wanted to wrap it up. That sub was never going to come back, and they were the only one who could fix that piece, so we just took money. And it was okay. It was arms like everybody shook hands, we were okay. So there is a way of getting there. But your subcontract should have some kind of notice if you're going to be charged something. So look out for those areas. The amount of the back charge could be challenged if they're overcharging for things you're not responsible. Or if there was another sub who caused the problem, not you, you can try to use that as a defense. Or you say the work was fine, it's not defective, and you're trying to charge me unfairly. And then for certain things, they have to tell you ahead of time. So, you know, sometimes when you produce multiple articles, places will ask you to have the first article inspected, make sure it's good. Okay, build the rest of them like this. And you might have gotten the go-ahead, did a bunch of them, and now with the 30th one, they go, oh, wait, they're wrong, go back and redo them. Well, no, I mean, if you already delivered a lot and met it, you should be able to have an argument that they're overstepping and asking you to redo work that is acceptable within the contract. Sometimes, it's rare, BART puts in a requirement and what is produced actually meets what we said, but didn't really fit what we wanted. Ideally, they catch it ahead of time, but every once in a while it happens, and it's not the prime's fault. They gave us what we asked for. It's just this thing doesn't transpond or conduct the way we thought. We had one issue just this last year on lighting. A certain kind of lighting project we have in one of the stations. We specified the kind of efficient lights to put in because they would get a certain luminosity, illumination. And the company told us to put their product, promised it would work. So we put it in there. So the prime bids, they give us the product. We're like, this is so dim, you're not meeting the specs. We gave you what you asked for. You did? I go, sure enough, it's the model, everything. It just didn't work the way in the lab and the way the vendor told us it would work. So it wasn't the prime's fault. They brought us the product we asked for, but it didn't work. So if someone's being charged to replace them, that should not be the prime or the sub-supplier who came in to help them and be on their ticket. We had to absorb the cost of that, and we're still trying to figure out what went wrong with it.